Hi, I'm Rahel Philipose and you are listening to Three Things, the Indian Express News Show. The death penalty in many ways is considered the ultimate and harshest punishment by the state. And while it's held to be constitutional, many accuse that the manner in which it is carried out is often unfair and arbitrary. For example, there are times when the person's circumstances are overlooked, and it's people from marginalized backgrounds disproportionately facing the brunt of it. And this is the reason why the Supreme Court has in the past called for reforming the way death sentences are administered by the court of the country. But despite this, last year, a total of 165 death sentences were awarded by the trial courts in India, the highest in a single year since 2000. This is what the 2022 Annual Death Penalty Report has revealed. A report which is released by Project 39A, a criminal reforms advocacy group with the National Law University, Delhi. In this episode, my colleague Utsa Sarmin speaks to Professor Arup Surendranath, the Executive Director of Project 39A, about the issues surrounding the death penalty in India and the reforms it needs.
Anup, for a long time, the Supreme Court of India has been talking about the need to consider all possible alternatives to the death penalty before imposing it, and has said that the death penalty should only be used in the rarest of rare cases. So could you explain what would qualify as the rarest of rare case?
Yeah, look, that's at the heart of much of the problems with the death penalty as to what is the meaning of rarest of rare, and it has led to a lot of confusion and arbitrariness and inconsistency in what courts across different layers of the judiciary have done. It came in the 1980 in Bachan Singh when the Supreme Court was asked to decide whether the death penalty is constitutional. While the court said, yes, it is constitutional, subject to death sentences being determined in a certain framework that was laid down in that judgment. And they said, look, you have to first identify, once you find the person guilty and then you move to deciding what punishment to give, you have to decide what are the aggravating factors, what factors contribute to saying this person deserves higher punishment, aggravating factors. Also, I have to identify mitigating factors, which then are factors that are towards reducing the sentence. So you have to identify both. And then you have to give appropriate weight to all these factors and then decide whether it is deserving of the death sentence. And one of the factors to deciding that is the alternate option of life imprisonment unquestionably foreclosed, right? And the law is very clear that it is not just the circumstances of the crime or the nature of the crime that is relevant. It is also circumstances of the accused person that is relevant. So you have to look at that person's background, that person's life, that person's conduct in prison, the probability of reformation, right? So you have to look at a whole host of factors. You can't just say, oh, look, the crime is brutal, the crime is heinous, and that alone can't be the fact. And the judgment in Bachan Singh in 1980, which laid down this framework, is very clear. So your special reason to give the death sentence, to give the higher punishment and not give the default punishment can't just be crime-based. And that's what has happened over these 42 years when death sentences are imposed. Judges, when they want to give the death sentence, just say that, oh, look, this crime is so brutal. This person is not even a human being if this person can do such a thing. But that's not the way the law envisages, right? That's how the general public might want to go about this. But that's not what the law requires. And, the history of the rarest of rare doctrine is one of complete judicial non-compliance between what the Supreme Court said it should happen in 1980 and what has happened over the last 42 years. Yeah.
Okay, so the court, among other things, has to look at the possibility of a life sentence and whether the person can be reformed before giving the death sentence. But Anup, could you also just walk us through the whole process of how death penalties are administered in India?
Look, first of all, you should be found guilty of an offense which carries the death sentence, right? At the trial court level. And India does not have the mandatory death sentence. No offense can have death sentence as the only possible punishment. Let's say murder. So the punishment for murder in the Indian Penal Code is that judges can either give life or they can give death. So now in any trial, there are two phases. The first phase is, am I guilty or not, right? So that is a guilt phase. So there they use the Evidence Act and they look at what evidence is there, the Criminal Procedure Code. The trial is conducted to see whether am I guilty of murder or not. Now, once the guilt is determined, saying, yes, you are guilty, in the trial, we move to the next phase known as the sentencing phase. The sentencing phase is where the judges have to determine the punishment for the offense that you have committed, right? So in the sentencing phase is where judges have to do this process that I was talking about of looking at aggravating factors, mitigating factors. They have to call for this material. Lawyers have to present these materials. Then judges have to apply their mind to circumstances of the crime and also the circumstances of the accused person's or the guilty person's life in all its complexity and its various facets, and then has to come to a determination whether special reasons exist to give the death sentence or not. So once a trial court gives a death sentence, it goes to the High Court for what is known as confirmation. The High Court has to confirm. So you cannot carry out a death sentence only on the basis of a trial court judgment. The High Court has to confirm the death sentence, right?
Right, and after this, a person can also appeal this death sentence in a High Court. But what happens if the High Court also confirms the sentence?
Yeah. So now let's assume that the death sentence is confirmed in the High Court. Then I can come to the Supreme Court in appeal, right? The Supreme Court may or may not hear my appeal. And then now the thing is that they do hear death sentence appeals. There is no question of saying, no, we don't want to hear this appeal. They do hear the appeal. Now, even if in the appeal, the Supreme Court also gives me the death sentence, then I can file a review petition in the Supreme Court to review the Supreme Court's own decision that the death sentence is called for. So I can file a review petition. After the review petition, I can file a curative petition in the Supreme Court. Again, very limited, very, very narrow reasons for why you can file a curative, but you can. There is the option of filing a curative petition. Now, once all these judicial remedies are exhausted, I can file a mercy petition under the Constitution, either to the governor or to the president, or one after the other. Then if my mercy is also rejected, then I can challenge the rejection of the mercy in the High Court and the Supreme Court through a writ petition. So that has nothing to do with guilt or no guilt or whatever. That is looking into, did the president or the governor have good reasons, or did they exercise their power in rejecting my mercy in a fair manner? And then even if that doesn't succeed, then death warrant is issued. Death warrant is basically setting a date and time for execution, and that's carried out.
And once the sentences are appealed, do we know how many of them lead to acquittals and how many of them are actually confirmed?
So if you look at statistically over the last 2 decades, a little over 2 decades, what happens to these trial court death sentences? Ultimately, what the statistics play out in this following manner: about 35 to 40% are acquitted. Further 50 or 55% are commuted. What I mean by that is that the punishment is reduced. So while they say, yes, you are guilty, we will reduce your punishment from death sentence to life imprisonment. So the problem of the death penalty in India, unlike the American one or the Chinese one, or even the Pakistan one, right, that we are sentencing a lot of people to death unnecessarily, where there in those jurisdictions executions are also very high. Here we are sentencing a lot of people to clearly unnecessarily we are putting them on death row. And given the slowness with which our system progresses, right, and very often people don't appreciate or want to hear that it is great suffering to live on death row. You might say, yeah, what is the problem? You have all these options, you can go through all these years. That's very easy for us to say. But when you are living on death row, you don't know how long you have to live, how quickly the government will move these cases, how quickly the courts will move these cases. So you're living under this constant fear of death. And that is the real torture of the death penalty. Constantly swinging and this uncertainty between life and death. And especially given these high numbers of acquittals and commutations, it is shocking that the system subjects people to such suffering unnecessarily, right? And where there's absolutely no legal justification to be subjecting people to such suffering. Yes.
Right. In fact, in 2022, in the 68 cases decided by the High Courts, only 4 death sentences were confirmed. So, Arup, if the death sentences are unlikely to be upheld by the higher courts, what is the reasoning behind trial courts imposing so many sentences?
Yeah, we all assume that it is only the law that matters, and it is not just the law that matters. And if you talk to trial judges, and at least that's a sense I have gotten from talking to trial judges, is that, look, many of these cases you might not read in national newspapers. It's not making the headlines like Delhi gang rape or whatever else, right? Or any of the other cases that we are seeing now. It doesn't make those national headlines, right? But doesn't mean that those are not very high profile local cases. And we often underestimate the kind of pressure district judges are in these cases, right? So their thing is, okay, I mean, if you're guilty, and I think, whatever, in their own assessment of evidence, if I'm guilty and these are the kind of offenses, their assessment is, okay, I will give death. If the Supreme Court or the High Courts want to give you relief, then they will give you relief. Why should I take on this burden of not giving? Because there's immense pressure on them in those local contexts, which we don't appreciate, right? And yes, in judgments, whatever is written, but there's a lot that is happening that we don't get to see in judgments. And for me, I think that drives this exaggerated use of the death penalty, despite knowing that it's highly unlikely that the probability of the death sentence you're giving being upheld is extremely low. But look, as was called in an earlier report, it is a lethal lottery because you never know who are the ones that then become the unlucky ones in this deeply flawed process, right? And that is another facet of the cruelty of the death penalty, right? That you don't know who's going to be in those 5 out of those 100 or 7 out of the 100 who will then go through all the processes, right? And what factors play and what factors don't play. And I think it is fairly obvious. It is not just about the law. Yeah.
Right, and the top court in the past has also noted this arbitrariness in awarding the death penalty and has called for a reform of the process. And this is also concerning because studies have shown that it is largely underprivileged minorities, people from the scheduled caste and scheduled tribes that are awarded death sentences. So could you talk about that a bit?
So you're talking of people who are extremely poor, right? Who don't have proper legal representation, who don't have access to expertise and professionals who can collect this information and present it in court. So while the law said, yes, death penalty is constitutional provided you bring all of this information into court and then you do this great process of determining whether it is rarest of the rare or not, the foundation on which it rests is that this information will be collected. But given that you're talking of extremely poor people, irrespective of, let's say, even forgetting social identity, nobody will deny that those on death row are extremely poor. Who is going to collect it on their behalf? And that the court has ignored or has not paid enough attention to 42 years. And finally, it is fantastic that the court, at least even if though quite late, it has recognized that this is a severe point of crisis. Because doing this without collecting appropriate information goes against the rule of law. It is not a fair trial. That if you're supposed to collect it and nobody's really collecting it and nobody's making a serious enough effort and nobody has the expertise to really collect it. So the court is saying, let's try and fix it. Whether it can be fixed or not is a separate question. Everybody thinks these are things you can reform in the criminal justice system, but you're talking of entrenched inequalities and lack of capacity. So the courts believe we can go down this reformatory zeal and fix these. Let's see, right? Whether it can be fixed or not. At least now we've done step one. We've done step one of saying this needs fixing. And I think many decades down the line, we will realize that this is not fixable, right? Yeah.
You mentioned that the Supreme Court has already taken the first step. So could you elaborate a bit more on that and talk about what that has involved?
Yeah. So look, the court is looking to address broadly two main questions, right? And it has asked for a constitution of a 5-judge bench, which is a constitution bench to address this. The court is not deciding whether the death penalty is constitutional or not, right? It is deciding the process by which the procedural safeguards that must be there. So two broad questions that the court is looking at. At what stage should such information be collected about the mitigating factors of concerning the accused? What should be that kind of material? So at what stage should it be collected? What should be that material and who should collect it? That's one set of questions. The second question is that very often the sentencing hearing, remember I said that the trial is split into two aspects, which is the guilt phase and the sentencing phase. A big problem and a problematic practice in the trial courts is that sentencing is carried out on the same day as the day on which you are found guilty. So I might be found guilty in the morning, right? And the judge will say, now we will have the sentencing hearing in the afternoon. Now, in between this morning and afternoon and those 3-4 hours in the middle, how do you expect anybody to collect all this deep, complex, sociological, psychological, biological, cultural information that is required for a sentencing hearing and present it before the judge? So this whole idea of same-day sentencing, a very large proportion of death sentences in India are given on the same day as on the day on which the guilt is found. And the point being that if you carry out same-day sentencing, you are effectively not giving the accused any real chance to present information that a judge should have when deciding the death sentence. So the collection of material is one set of issues. And the second issue is same day sentencing, can it be said to be a constitutionally valid practice? And or does it necessarily mean that you're frustrating the opportunity of the accused to have a fair shot at sentencing? Yeah.
And do you think this will have any impact on the way trial courts are awarding death penalties right now?
No, I mean, look, that is a big problem for the court right now, right? Even last year, even though they said reforms are required, they themselves said in certain other death sentence cases that they decided that this is what you need to be doing. You need to collect this information, all of that. Now, the Supreme Court seems to be on a completely different trajectory on this issue of saying, yes, there are problems. These are some of the steps we should start taking straight away while we wait to decide for the Constitution bench to address these issues. These are the steps we must take. And the Supreme Court itself is doing that in all the cases that it is hearing, right? It is calling for these reports from the prison, from what is the probation officer, from the mental health expert. It is allowing access to a mitigation investigator from the defense's side. But the trial courts are functioning as though none of this is happening. They are singing their own tune. So of these 165 death sentences that have been handed out, you will see how the processes that the Supreme Court is saying you have to follow is just completely ignored. It's like as though they're not even aware. They might actually not be aware, but there is no justification for a trial court in this country to say that, oh, we are not aware of what the Supreme Court is laying down as law in this area, right? And that's precisely the situation we find ourselves in now. The Supreme Court and the trial courts of this country are completely in opposite directions. And that crisis really needs to be resolved because on an everyday basis, you are now sentencing people to death. And the trial courts are doing it completely oblivious to what the Supreme Court is saying is the process you should follow. So yeah, I don't expect that to change. Really. Yeah.
And Anup, when we talk about how the nature of crimes is prioritized, we have seen how in cases of sexual violence, like in the case of Nirbhaya, the court quoted collective conscience while sentencing the accused. The court said the crime is bound to shock the collective conscience and a lesser punishment would shake the confidence of the public in the criminal justice system.
So the support and the popularity for the death penalty is riding on the back of sexual violence in our country. And that presents complex questions, right? As you have seen post 2012, the amendments to the IPC and the POCSO since then have introduced more and more death eligible offenses. And because sexual violence is obviously such a serious issue in our society. But I think opinions are clear and divided on whether harsher and harsher punishments will really bring down sexual violence in our society. Yeah, but I think the feminists on this have a very different view on whether punishments are really what is needed to solve sexual violence, right? There seem to be different views on that. I think it just comes down to judicial discipline, right? Judges are supposed to decide cases according to the law, not according to what people want. Judicial proceedings, legal proceedings are about what the law requires, right? And it is not a forum for giving effect to public demands. And I think our judges and courts would do well to recognize that. And unfortunately, the death penalty is a great example of where that is often forgotten. And then you try and bring in all these notions of collective conscience or society's cry for justice and, all these other phrases that get pulled in. And the Supreme Court has been very clear that those are irrelevant considerations when deciding what punishment to give me for murder. Point being, even at the threshold level, as a judge, you have no real business considering public opinion and collective conscience as a factor in determining my punishment, right?
Right, and Anup, lastly, how does India compare to other countries in terms of awarding the death penalty?
Yeah, look, we are in a global minority now. There are about 142 or 144 countries that do not use the death penalty anymore. We are in a minority of about 50. I don't think we'd enjoy the company that we keep in that list of 50 countries. And I think there is a certain arc of this, of where the death penalty is going. It might take some time, but it is an inevitable arc, one would think. Whether it takes a few years, decades, whatever, but there is a certain arc on which we are, right? And I think the only challenge before us is to say that we should try and ensure that, some individuals don't end up being the victims of this lethal lottery.
You were listening to 3 Things by the Indian Express. Today's show was hosted, written and produced by Utsa, Sarmin and me, Rahel Philipose, with the help of Shashank Bhargava. It was edited and mixed by Suresh Pawar. If you like the show, then do subscribe to us wherever you get your podcasts. You can also recommend the show to someone who you think will like it. Share it with a friend or someone in your family. It's the best way for people to get to know about us. You can also tweet us at Express Podcasts and write to us at podcasts@indianexpress.com.